Welcome to the Pennsylvania Case Law Update While You Drive podcast. You give us less than 20 minutes per week, we will make sure you never miss changes in the law. This week's episode is brought to you by the McShane Firm. For nearly 20 years, the attorneys of the McShane Firm have been trusted by our neighbors and our friends to represent them in DUI and criminal law cases.
Thank you for joining us for episode 10 of the Pennsylvania Case Law Update While You Drive podcast. I'm your host, Katie McShane, and today we're covering cases decided between August 19th and August 25th, 2020. We will start this week with a constitutional law challenge. Haveman and Spillane v. Board of Professional and Occupational Affairs addresses whether the requirement of good moral character in order to obtain a cosmetology license violates substantive due process. In this case, two petitioners who were otherwise qualified to obtain a license as certified cosmetologists were denied because they did not demonstrate good moral character based on prior criminal histories. The petitioners claim that the statute requiring good moral character is unconstitutional on its face. A statute is facially unconstitutional when there are no circumstances in which the statute would be valid. The court found that the statute was rationally related to a legitimate state interest of the protection and patrons of beauty shops. However, the court ultimately found that the law violated equal protection as only cosmetologists were required to demonstrate good moral character and barbers who performed similar services were not. The court agreed with petitioners that it is absurd that where even if they have identical criminal records, even if they will perform similar services, even if they will stand one salon chair apart, the law requires good character of only the cosmetology applicants and not the barber applicants. Because there is no set of circumstances under which this requirement would be valid in this context, the requirement on its face violates the equal protection mandates of the Pennsylvania Constitution. Up next, we dive into the criminal cases for the week. Commonwealth v. Wilson is a DUI case addressing the sufficiency of the evidence and whether or not the officer had a reasonable suspicion to conduct a traffic stop. In this case, the defendant was driving in the left-hand lane, going less than 60 miles per hour, but above the posted 55 mile per hour speed limit. There were cars in the right-hand lane that he was passing. The corporal was en route to his station for another matter. When he came behind the defendant, he felt the defendant was driving too slowly, so he chirped his siren one time. The defendant did not move over at that time. The corporal then put on his lights and sirens full, and the defendant immediately pulled over to the left shoulder. The corporal was upset with this action and pulled to the right, then yelled across the street to the defendant and demanded that he move to the right shoulder, which he did. The defendant was subsequently arrested for DUI. At the trial court, the defendant filed a motion to suppress, claiming no reasonable suspicion to conduct a traffic stop. The trial court concluded that the stop did not occur until the corporal demanded that the defendant move to the right shoulder, and at that time, the corporal did have grounds to conduct a traffic stop and denied the motion to suppress. Following a stipulated bench trial, the defendant was convicted of restrictions of use of limited access highways and 2 counts of DUI. On appeal, the Superior Court rejected the position of the trial court. First, regarding the restrictions of use of limited access highways, the Superior Court found that where the defendant was driving in the left lane, passing another vehicle in the right lane, and traveling faster than the flow of traffic, there was insufficient evidence to sustain a conviction. In regards to the suppression, the court found that even though the corporal did not initially intend to cite the defendant with anything, the moment he chirped his siren, a reasonable person would not feel free to leave, and that is the point in time the seizure occurred. The court must then determine if the corporal had specific and articulable facts which led to him to reasonably believe that the defendant had violated the motor vehicle code at that time of the seizure. The Superior Court concluded that he did not. The Superior Court found that the trial court should have granted the defendant's motion to suppress, and the judgment of sentence is reversed. Commonwealth v. Manzano involves the constitutionality of a determination as a sexually violent predator, or SVP, under the Sexual Offender Registration and Notification Act, or SORNA. The appellant had pled no contest to a number of sexual offenses. Following his plea, he was sentenced to 15 to 30 years imprisonment, followed by 51 years of probation. He was designated an SVP and required to register under SORNA. At the time of the appeal, the court had previously held that the provision of SORNA requiring the court to designate an SVP by clear and convincing evidence violated the Constitution because it increases an offender's criminal penalty without requiring proof of that fact beyond a reasonable doubt. However, while this appeal was pending, the court reversed their previous decision and instead found that an SVP designation is not a criminal punishment as the primary purpose is deterrent of threats and community protection. Therefore, it is not unconstitutional to designate an offender as an SVP. The appellant is therefore afforded no relief in this issue. Appellant next argues that subchapter H of SORNA, which designates that appellant must register for life, is also unconstitutional. The court held that while Subchapter H has been determined to be unconstitutional in some cases, it is not unconstitutional on its face. In this case, the appellant failed to produce any scientific evidence supporting his claims that Subchapter H violates his constitutional rights, unlike the previous cases where it had been found unconstitutional. For that reason, the appellant's request for relief is denied. In Commonwealth v. Little, the defendant was convicted of murder. The issue at trial was whether or not the defendant was the one who shot the victim. Two eyewitnesses for the Commonwealth who say the defendant shot the victim had substantially different recollections as to what happened. The defendant presented the testimony of a witness who claimed that he, and not the defendant, had shot the victim. That witness was currently serving 2 consecutive life sentences, and the Commonwealth repeatedly argued to the jury that the witness should not be believed because he had nothing to lose. Defense counsel sought to elicit testimony that the witness could be subjected to the death penalty if these murder charges were brought against him. The Commonwealth objected, and ultimately the judge ruled with the Commonwealth. When defense counsel was directed by the judge as to what he was permitted to ask the witness, he failed to reassert his objection. For this reason, the issue is deemed to be waived on the defendant's direct appeal. In this PCRA matter, the defendant raises an issue of ineffective assistance of counsel for failing to object and preserve the issue. The court here found that the defense counsel was ineffective. In evaluating whether or not any remedy is available following ineffectiveness, the law mandates that the defendant must show a reasonable probability that the result of the proceeding would have been different but for counsel's actions. The strict interpretation of this rule would require a showing that the outcome of the specific proceeding would have been different. However, courts have been inclined to extend this rule in matters such as this. It is clear from the trial court that even if counsel had renewed their objection, the testimony would not have been permitted. Here, the court found that waiver of an appellate claim may be considered prejudicial when the impact of the error does not rear its ugly head until the appellate stage. The court ordered that the defendant was entitled to raise the issue so that its merits may be considered as if it were raised for the first time on direct appeal. The case of Commonwealth v. Rivera is a criminal case addressing the constitutionality of the felony murder rule as well as the rule regarding convictions for conspiracy. The brief facts are as follows. The defendant and 3 other co-defendants conspired to break into the victim's house and rob him of drugs and money. During the course of the robbery, the victim was shot and killed. Defendant was convicted of second-degree murder, robbery, burglary, and 3 counts of conspiracy. The defendant raised weight and sufficiency of the evidence on appeal, and the court found that the issues were waived as they were not raised in the post-sentence motion with sufficient specificity as to what elements of what crime had insufficient evidence. The defendant also claimed that the felony murder rule was unconstitutional as it allowed a court to infer malice rather than being required to prove malice beyond a reasonable doubt. The court found that the appellant failed to establish that the felony murder rule clearly, palpably, and plainly violated his constitutional rights and is therefore not entitled to relief. Though the defendant did not raise the issue of an illegal sentence for multiple conspiracies, the court addressed the issue anyway. The court held that to be convicted of multiple conspiracies, there must be evidence of multiple agreements being made. If multiple crimes are being committed as the result of a single agreement or continuous conspiratorial relationship, the defendant can be convicted of only one conspiracy. In this case, the original conspiracy was to commit robbery. The burglary and murder were part and parcel with the conspiracy for robbery. Therefore, the only conviction for conspiracy to commit robbery can stand. The court vacates the convictions and sentences for conspiracy to commit burglary and conspiracy to commit murder. However, as the sentences were all concurrent, no resentencing is required. We'll be right back after a brief note from our sponsors.
This segment of Pennsylvania Case Law While You Drive podcast is sponsored by the McShane Firm. The McShane Firm is Pennsylvania's largest and best DUI and criminal law firm. Their mission is simple. Make sure the presumed to be innocent remain innocent.
Welcome back. The final segment this week covers family law matters. In the Interest of AC is an appeal of finding of child abuse in a dependency case. Here, child sustained injury to the head. Mother claimed the injuries were caused from falling from a bed. Medical professionals opined that the injuries were inconsistent with a fall of that nature. Additionally, they noted old injuries as well during their examination. The trial court made a finding that the type of injury was consistent with child abuse and inconsistent with mother's explanation. Upon a finding of child abuse, the child was declared a dependent and placed in the custody of the Department of Human Services. Mother appealed. The Superior Court found that the trial court did not abuse its discretion as there was sufficient evidence to support a finding of child abuse. The second issue addresses whether it was proper to place the child in the custody of Human Services. Following a finding of dependency, the trial court may not separate the child from the parent unless that separation is clearly necessary. The trial court may make an order which is best suited to the safety, protection, and physical and mental welfare of the child. Here, the Superior Court found that the trial court properly focused on the best interests of the child. Given the child's young age and ample evidence supporting the conclusion that the child's health, safety, and welfare were best served by removing her from the home. Additionally, the permanent placement plan was focused on ultimate reunification with the parents. The Superior Court found no abuse of discretion. In the Interest of KD is a second case addressing a finding of child abuse. In this case, mother got upset when her live-in girlfriend refused to return to the home, presumably after a fight. Mother threatened to stab her child and threatened to put a plugged-in iron into the bathtub while her children were in it. During the hearing, mother claimed that she never intended to harm her children and would never harm her children. She was just saying these things to prompt a reaction from her girlfriend. However, it was also testified to at the hearing that mother held a knife against her child and that she did have an iron in her hand, and both kids were in a bathtub. The trial court found that this was sufficient to sustain a finding of child abuse. The Superior Court affirmed, holding that it's sufficient to engage in a reckless manner, meaning consciously disregarding a substantial and unjustifiable risk, even when no injury occurs. Creating a reasonable likelihood of injury is enough to sustain a finding of child abuse. In the matter of KTR versus LS, the court addressed timeliness of an appeal filed in a custody matter. Here, a custody order was entered on May 24, 2019. Father filed a motion for reconsideration, which was granted. There was a hearing scheduled on the motion to reconsider for September of 2018. Following that hearing, Father requested additional testimony. That request was granted on October 28, 2019, and an order was entered scheduling a hearing for additional testimony on December 27, 2019. Father filed this appeal on November 14, 2019. This appeal is premature. Since the court issued an order for additional testimony, the reconsideration decision did not have to be rendered within 120 days, and the time for filing notice of appeal will run from the date the reconsidered decision is rendered. As the appeal is premature, the appeal is quashed. Thank you again for joining us, and I hope you have the best week ever.
Thank you for listening to the Pennsylvania Case Law Update While You Drive podcast. Be sure to subscribe to this podcast and our YouTube channel to make sure that you are always in the know when it comes to important changes in Pennsylvania case law. We want to thank this week's sponsor, the McShane Firm. The McShane Firm is a central Pennsylvania fixture when it comes to DUI and criminal defense. The attorneys and staff at the McShane Firm believe in good old-fashioned central Pennsylvania values like hard work and straight talking. Give them a call if you or a loved one ever needs help.